Representative Shaw. Let's see.
Thank you, sir.
We're good.
It's 10 o'clock. Let's crank this thing up and get going. Who's your secretary today?
John.
Okay, John, if you'll take the roll, we'll make sure we have a quorum. I think we do, but we'll get it official. Dan Howe's not here. He's not feeling well and running a temperature, and I told him to stay home and don't come in. So he did. You've got me the whole time. We'll get this thing moving here in just a minute. Go ahead and take the roll.
Senator Bailey. Representative Bricken.
Here.
Senator Campbell.
Here.
Representative Darby.
Here.
Representative Dixie. Chairman Gardenhire.
Here.
Representative Hicks of Rogersville. Representative Hicks of Washington.
Here.
Chairman Howell. Representative Littleton. Senator Rose.
Here.
Representative Shaw.
Here.
Senator Sutherland.
Here.
Senator Watson.
Here.
Senator Yeager.
Here.
Senator Yarbrough.
Here.
You have a quorum, Mr. Chairman.
Thank you. Let's go to the consent calendar on statewide contracts. Is there any comments or questions on the statewide contracts on the consent calendar? I see none. We're ready to vote. All in favor say aye.
Aye.
Opposed, nays. Ayes have it. On the consent calendar, we have agency terms. Do we have any comments or questions on those contracts? I see none. We're ready to vote. All in favor say aye.
Aye.
Opposed, nays. Ayes have it. We move down to our regular calendar. Labor, you're up. And if corrections, if you'll come up, you're on deck. You're up on contract number 1 with Fast Enterprise. You're recognized.
Good morning, Chairman Gardenhire and committee. My name is Matthew Grove, Legislative Liaison with the Tennessee Department of Labor and Workforce Development. The department brings 2 amendments to our existing contracts with Fast Enterprises LLC to include managed hosting services for both the unemployment benefits system contract and the employment tax system contract. The first amendment is for the unemployment benefits system contract, increases the maximum liability by $2,025,760 to $41,744,855. The Fast Enterprises LLC unemployment benefits contract was awarded via RFP in September of 2022. Managed services include hosting support, issue reporting, infrastructure administration, monitoring, testing, audit support, data protection, security, disaster recovery, business continuity, and availability. The amendment request for Fast Enterprises is to continue managed hosting services under the state's new cloud model. SCS now has a cloud cost model that allows the vendor to manage their infrastructure within the state's tenant and Amazon Web Services AWS. Using this model is more cost and labor efficient. These managed hosting services will provide the necessary infrastructure and optimization to ensure the system meets the needs of Tennesseans. We're glad to answer any questions from the committee. Thank you.
Questions or comments on this contract? I see none. We're ready to vote. All in favor say aye. Aye. Opposed, nays. Ayes have it. You're recognized on contract number 2 with Fast Enterprises also.
Thank you, Chairman Gardenhire and committee. My name is Matthew Grove, Legislative Liaison with the Department of Labor and Workforce Development. The second amendment we bring for your consideration today is an amendment for the unemployment tax system and does not increase the maximum liability. This contract for the unemployment tax system with Fast Enterprises LLC was awarded via RFP in March of 2024. Managed services included hosting support, issue reporting, infrastructure administration, monitoring, testing, audit support, data protection, security, data.
We have a motion. We have a second. We have a motion and a second. Any comments or questions from the panel? I see none. We're ready to vote. All in favor say aye. Aye. Opposed, nays. Ayes have it. Thank you very much. Corrections, you're up, but let's get the health and facilities up here on deck. Thank you. Before we entertain this contract and the people from corrections, I'm going to ask that Senator Yeager, do you have a comment?
Yes. I do. Regarding the contract extensions of company, the matter we discussed, Mr. Chairman, okay, yes, I do. That I do think that there's a concept that ought to be considered by this group, that no company should be eligible for a new contract or contract extension in the same service if the company has been penalized by a state agency for significant violations in that service for the past 5 years, Mr. Chairman. I appreciate your discussing this issue with me, and I'll be happy to defer to you or for further comment.
Thank you. This one on corrections, I'm going to move that we move this contract off to next month. Evidently, the people at the corrections department has not given the staff the answers to the questions that were been asked. So we're going to postpone this contract until next month, and in hopes that the Department of Corrections answers fully and correctly the questions that the staff has been asking. They're getting answers, but they don't really say anything about it. So with that, I'm going to move that we,
Second.
and I got a second by Senator Yeager.
Yeah.
Chairman Yeager, I'm sorry. And did you want to make any more comments about correction?
Yes, I do, and I apologize. I thought the chairman was asking me about another issue that I planned to comment on in my earlier statement to you. But I do strongly support this issue for the reasons that the chairman has set out, and would encourage a positive vote on this because for the very issues that the chairman has alluded to. I also think that part of that discussion, we have a pharmacy management manager for the state of Tennessee. Then I want to know, in addition to the chairman's concerns, my concern is that what the effect of the execution of this contract that corrections proposes that would how it would affect the contractual obligations of the PBM. So I strongly second your motion, Mr. Chairman.
Comments or questions from the panel about delaying this for 1 month? I see none. Ready to vote and send it off to next month. All in favor, say aye. Opposed, nays. Ayes have it. Thank you. We got health facilities getting ready to start, but TennCare, if you want to come up and go on deck, that'd be great. Corrections, I would suggest that you have the staff of the corrections department get with our staff here and cooperate with. It's not your fault. You're just been asked to come up here and be the messenger, but we would like to send a message back to the people at corrections that they need to start they need not to dodge the questions and to answer what the staff wants to know about the contract. So thank you very much. And we're sorry to put you on the spot, and we know you're the messenger, but they need to get the message. Thank you. Okay, we're going to have health facilities. Oh, you're up. Glad you're with us today. Go ahead. You're up.
Good morning, members of the Fiscal Review Committee. My name is Logan Grant. I'm the Executive Director of the Health Facilities Commission. With me is John Carr, our Fiscal Director. And what we're asking for your approval for today is a bridge contract to correct an issue that came up when we competitively procured a contract with DNS to process the applications and of certified nursing assistants. And in that contract, we anticipated that they would be imposing a $25 fee on applicants. And that is consistent with what is done in several other states. Of those fees, the $25 is the lowest amount. And so when we were going to proceed with the contract, as a licensing agency, we generally have broad rulemaking authority to impose fees, but we discovered after the contract was in place that we did not actually have the specific rulemaking authority for the contractor to impose that $25 fee. So what we've done is take some money out of our reserves to cover that fee up until June 30th of 2026, at which point we expect to have the rule in place.
Thank you. We have a motion and a second. We have discussions, Representative Bickering first and then Representative Shaw second.
Thank you, Mr. Chairman. We discussed this contract yesterday on the phone. I just have 2 points. One, back in March when this was discovered, I guess it was in March, that y'all didn't have the rulemaking. And there, 5 months later, we're here to kind of amend it, make the contractor whole by over $500,000. A couple of things, and I'm not on government ops. I'm not with the Attorney General's office. And just from our federal legislators, it seems like there should be some expedited rulemaking way that we would have to get this rule done faster so the state can save this $500,000 or a portion of it. Rather than waiting till July of 26. I understand the protocol that we have of preparing rules, going to government ops or going to Attorney General. I'm not sure which goes first, then Secretary of State's for 90 days. That all just seems lengthy when we have a very pragmatic, very simple issue that should be able to be expeditedly addressed. And that's, again, that's more of a statement than anything else. The last thing is that the $550,000 just floors me because that's 22,000 reciprocal or renewal contracts. And I've shared that on the phone. That just seems like an exorbitant number for this period of time. So those are my comments.
Let me ask the panel if somebody's either is or was on government operations can go through that you talked about. Does anybody want to comment on that?
I'll help.
Chairman Watson, I thought I would get your attention on that, so go ahead.
And I'll ask the agency, I mean, there is, to the member, there is an emergency rule process that you can utilize that expedites the rulemaking process. In the process, though, even under an emergency rule, it then goes to the Secretary of State's, goes to the Attorney General first for review. Then it goes to the Attorney General's office for, then it goes to the Secretary of State's office for posting. Then it goes to the Government Operations Committee for a review and ultimately a vote. But you can be expedited through emergency rules. We do that periodically with legislation that passes that has an effective date faster than the rules can be. Go through the normal rulemaking process, which usually takes somewhere around 6 to 9 months under normal conditions. And to the agency, I don't know whether the emergency rule process was something that y'all have considered.
Mr. Grant, you're recognized.
Thank you, sir. We did consider that. And what we decided, the reason why we decided to approach it this way was, for one, we weren't sure that it would, if it were evaluated by the Attorney General's office, that would meet their standard for an emergency rule. Secondly, also, we kind of are implementing this new renewal process for CNAs, and there were some concerns from the industry about how this was going to work, and it was the implementation of imposition of a new fee for a lot of their employees, and so there were concerns about that. So we thought that it would be a good way to proceed to try and ease those concerns by giving them some more time to talk to their folks about it, because there may be some employers that want to cover that fee for their employees or not. But we thought it was a good opportunity to give them some more time to adjust and prepare for it.
Representative Bickering, or you want to follow up with a question or comment?
well, I'm sure.
Microphone. Pull your microphone closer.
Came about. I'm sure
when y'all proposed the original rules, or that should have all flushed out any industry considerations. They knew it was coming, and it only got challenged by, I'm not even sure what agency said y'all didn't have the authority, agency or
Those are internally.
Okay.
Internally, our Office of Legal Counsel advised us that we would be better off on getting the rule.
Again, that a lot of that should have been flushed out. I'm just saying that this is costing the state $550,000 that we're
collectively paying. And it should have been minimized or expedited to cut it in half if you expedited a rule. I'm not sure what an emergency is. If I could save a couple of $100,000, to me, that's an emergency. But that's how I think. But that's all I have, Mr. Chairman.
Thank you. Representative Shaw, you asked a comment.
Thank you, Mr. Chairman. I make the motion because I had a chance to discuss this with the department this morning, and I'm not sure right now whose fault it is, if there's someone to blame this on. And I don't know if they should be held hostage because it didn't happen. I just think maybe for the best interest of the department, it'd be best if we could go ahead and pass this out. That's my comment.
Thank you.
Yeah.
Any other comments or questions from the panel? Chairman Watson.
I think, just want to take a minute so the members can consider, because I understand the representative's motion and I seconded it, but explain again for the committee to hear what the problem is with the rule. So you have a rule that is currently in place, if I understand correctly, that's gone through the normal rulemaking process that has existed. And the question before the agency from your internal legal counsel is that as the rule exists today, you are not given explicit authority to impose a fee on the CNAs. Is that a correct interpretation?
I apologize if I misspoke or mischaracterized it. We had the contract in place. The rules we had not changed. When we were working on the contract, we had proceeded essentially taking for granted that the rulemaking authority, the rules that we had in place would give us authority to impose this fee. But then upon further examination, we discovered that the CNA program specifically, the rules governing that do not allow us to impose a fee. And so that was something that we discovered later. So what we have to do now is get the rule in place. And we expect to do that by June 30th of 2026, at which time this bridge contract will expire. And then they'll go on to charging the fee to the applicants.
Well, to the members' comment, I think perhaps in light of this hearing, an ask of the Attorney General to review your ability, your ability whether you can impose a fee or not, coming from the Attorney General. They would have reviewed the rule that it exists today, so they should be able to comment on it. And two, given the hearing today, does it meet the standard of an expedited or emergency rule that would allow you to move forward? And to that, you would. So I don't know what kind of time frame we're on here, Mr. Chairman, and whether allowing them the opportunity to get a response back to that question, or whatever the will of the committee is. But I think it's a fair question about the financial implications to discuss.
We can put it off. Yeah. Mr. Grant, I've gotten a nod that it wouldn't be disruptive to put this off and get those answers if you're willing to do that. Well, we will follow Chairman Watson's suggestion and have y'all come back with a clarification of that. Is that okay with y'all?
Absolutely. Happy to
Okay,
do it.
great. All right. Thank you. Thank you, Chairman Watson, for bringing that up, and Representative Shaw, thank you. We'll go on to 10 Care, and if Human Resources, you're on deck, so you might as well come up, even though they have 3 contracts. You're up. Thank you.
Good morning, members of the committee. My name is Zane Sills, and I have the privilege of serving as the Chief Financial Officer for the Division of TennCare. Our first contract before you today is a competitively procured contract with Deloitte Consulting. This amendment seeks to extend the contract by 12 months and increase the maximum liability for that period. In this contract, Deloitte manages our eligibility determination system, TennCare Connect. So if somebody applies to be on the TennCare program, this system manages that process and their ongoing eligibility the entire time they're on the program. Our system has been widely successful in unwinding the federal public health emergency. As I've talked about before this committee, our enrollment ballooned from 1.4 to 1.8 million. It's back down at about 1.4 million. So we got through that process better than our budgeted projections. We're only we're in a minority of states that did not have to pause, and only a handful of states that did not receive a.
We have a motion. We have a second. We have a motion and a second. Chairman Watson, and then Yarbrough, and then Ms. Campbell.
Yeah, I do want to allow the department a moment to come, because I discussed this with them, with some of the forecasted changes that may be coming as a result of the passage of the One Big Beautiful Bill, and potential changes in qualifications and work qualifications, that this system that we've built over the past several years has the capacity to handle whatever's coming down the pike. I would like for you to comment on that.
Absolutely. Thank you for the question. Yes, we strongly believe this system is well positioned to handle anything that comes. Frankly, the impacts of the federal public health emergency were much more significant in terms of placing stress and pressure on the system than what we expect. Just as a non-expansion state, a lot of the provisions in the Big Beautiful Bill don't really apply to Tennessee. And so we're not really projecting significant pressures on this system at this point.
Follow up, Chairman Watson? No. Okay. Senator Yarbrough.
Sorry. Thank you. And so how long has this contract been going, and what's the increase in the maximum liability?
So we're entering the 11th year of the contract. The increase in the maximum liability we're requesting is a little less than 152 million. Gets enhanced matching dollars from the federal government. So the state share is a little less than 28 million.
I think usually there are a lot of contracts where this can happen, and I understand that there's practicalities, but I mean, the original maximum liability for this entire contract, was 129 million. So now, like, we're doing more than that each year on this contract, and it's in its 11th year. It's not like what was originally going to be a $130 million contract, give or take, is now over $1 billion. And so, I mean, my concern here is that what we got to make sure that we're doing is, when people are competing for the contracts that the state offers, that they're competing for the contracts that we're actually entering into. And so what you got to think is, like, if you're actually, like, I mean, I understand that there can be unforeseen circumstances, but there are always unforeseen circumstances. I mean, that's sort of the nature of the beast here. And, if you had, would your competition have been different? Would you have different people apply? Would you have gotten different cost offers if the contract had been advertised in the way that is more similar to what the contract is now? And I mean, I know that this one's coming back up, but I mean, there are just we got a lot of places where we have contracts where increasingly it seems like we're dependent on the vendors. And maybe that's just the reality, but if that's the reality, we got to change the policy. And I'm trying to figure out, like, what, how the department views this, and do you disagree with the normal policies, or what's going on here?
Great. I appreciate your question. I think there's maybe 3 different issues that you kind of touched on that, if it's all right, I guess I'll address. There's the question about the cost, question about the extended time frame, and then also potentially being dependent on one vendor. So maybe I'll address that last one first. As far as being dependent on one vendor, we don't feel like that's the case. This is just a really unique circumstance in that we would have reprocured this contract years ago had it not been for the federal public health emergency that put a moratorium on us doing any of our normal re-verification processes for 3 years, which, again, you've heard me talk about how that tremendously impacted our enrollment. We just felt like it was very unwise to reprocure this process while we were in the middle of that effort. So that extended this contract by multiple years beyond what would have happened absent the PHE. That competitive RFP is in place. or is about to be in place. We project that that'll be released around Thanksgiving. So we're pretty close to that going live. The question as far as if we're dependent on this one vendor, we don't believe so. The way we've structured this contract and this systems build is we own the system. Tennessee owns the system. And we made sure that in this contract that it was built in a way that another vendor could come in and operate the system. You never want to be in a place where you've built a system that essentially, even if you do a competitive RFP, there's realistically only one company that could bid on it. So we do anticipate having multiple bidders on this contract when we release it here in a couple of months. Certainly, I would imagine the incumbent will want to bid to continue services, but we imagine other vendors will bid as well. We own the system, and we'll be bidding out operations and management. So that kind of addresses that question and the extended time frame. As far as the cost, I'm not going to deny this is a lot of money, right? $150 million is quite a bit of money. When we enter into these contracts, instead of setting the maximum liability at the total estimated lifetime of the contract, or even including the option years, what we do is we just put the maximum liability for the original base years of the contract. And the reason we do that is because then when we exercise option years, we ask for the maximum liability. Then we feel like that's the most transparent way to approach this committee as far as what our annual spend is going to be. The reason that it was so small in the beginning was just because of the way the system build was scheduled to take place over a period of years. It's kind of a wave, right? The first years you're spending less money because they were doing some requirements gathering and stuff and actually not getting into the building of the system. And then as they built the system, it gets more expensive. And then it starts to kind of draw down in certain places from there. So that kind of, I guess, addresses our approach to how we set those maximum liabilities. Hopefully that answered your question. I'm happy to take any follow-ups.
Senator Yarborough, follow up.
Well, first, I want to just reflecting on the fact that Chairman Watson and I serve on Information Systems Council and deal with broken technology procurements, not infrequently. I sincerely applaud the fact that we're building our own system here that where we actually have some flexibility to deal with it. I mean, I guess the question that I'm trying to get to is, and it has nothing to do necessarily with like this particular vendor. I mean, it's much more, to making sure that what we're advertising is matching what we're intending. And it sounds like maybe that's what you're saying is that, I mean, because this was originally planned to be a 3-year with 3 1-year extensions?
This was originally a 7-year, a 4+3.
A 4+3?
This was originally a 4+3.
Okay. And so, but I wanted to make sure that it was always part of the way that was advertised. We anticipated the cost going up each year.
So yeah, that's a great question. I think we anticipate that costs will go up. I will say in the eligibility space, it's really difficult to predict what may come in the future. I'll give a couple of examples. We're constantly having things at both the federal and state level, laws and regulations that are being passed to tell us to do new things. We've had the Katie Beckett program in the past few years. About a year and a half ago, we had the legislature pass a law for the working disabled group. We're still waiting to get CMS approval on that. Anytime we get a program like that, we have to rebuild a component of the eligibility system to actually handle the very unique rules that go along with that particular population. So, certainly in 2015, I don't think anybody probably would have predicted Katie Beckett or the working disabled program all these years down the road. We understand things like that do happen, but it can be hard to forecast when a new program may be implemented.
Well, and just one final thing, and because I know we have a lot of contractors here. I mean, I think you'd be hard pressed to find many 7 or 8 year periods where you don't see changes like that.
Sure.
And I mean, I think we come across this in like the corrections context where, I mean, you can't program the offender management system to to not deal with changes in criminal and sentencing law. And I mean, I think we've got to figure out ways that we're building change into the system, and so that it's not that disruptive of endeavor or doesn't harm our ability to actually project out what we're doing. I guess that's a broader context about this contract, but also a lot of contracts that are very much like this that can get away from us as a state.
Thank you. Senator Campbell, do you have a question?
Thank you, Mr. Chair. So I know we've had roughly 555,000 people disenrolled from TennCare since the 2023 post-COVID situation. One question I have is, are we going to let people know that they can re-enroll? Because I know a lot of the disenrollment was due to various factors that were kind of beyond TennCare's control. But I want to know if there's going to be an active effort to let people know that they can re-enroll. And then my second question is, and this is just more of a question about I guess, systems integration. I mean, that seems like an extraordinarily long time for it to take us to do systems integration. And 11 years that seems like a long time to me. But I guess my question would be, are we going to see hopefully a very significant drop in the cost of this when we're just on maintenance for this? And how close are we to the end of this process?
Right. So as far as the first question, when we disenroll people because they no longer meet the eligibility requirements of the program, they do receive notices about what's happening and why it's happening. They receive multiple notices. Part of that notice process is they get referred to the Federal Health Insurance Exchange. Sometimes people that make too much money to qualify for TennCare, they still may be in an income band that they qualify for the health insurance marketplace, and there's subsidies from the federal government depending on what level of the FPL you're at, and even enhanced subsidies that are currently in place. So they get referrals and notices on that. And certainly, I believe are aware they can reapply for the TennCare program at any time. We'll make a determination on if they, at that point in time, meet the eligibility requirements. As far as your second question goes about the timeline, so we are in operations and maintenance, but then there's always construction going on to the system because of these new changes that get passed. So the system's already been built. It was launched in 2019, and that's what allowed us. We turned the new system on in 2019, and just as about the time it was coming online, March 2020, the federal government put a hold on re-verifications. So we went through 3 years of that. But the system is running. It's in operations and maintenance. But then there's this additional component that is always happening where there will be changes at the federal and state level about how eligibility needs to be determined, or we'll have new programs added like the two I referenced earlier. And anytime those happen, we have to make heavy modifications to the system to address those. And what we've learned, or what I've learned over 14 years, there will always be those. There's going to be something in 3 or 4 years that I don't even know about now that we'll be told to do, and then we'll react to that, and we'll have to modify the system for that. So we can be sure that in any given year there will be changes that we have to build into the system. So it's very much like Nashville. You go outside, there's always 20 cranes outside. The system is complete, but there's always 20 construction cranes on the system making the necessary modifications that need to happen.
Any follow-up? Go ahead.
Well, just one last question. I mean, obviously, we are burgeoning on a new era here with AI and those sorts of things. So I'll be interested to see, and I guess I hope that you all are anticipating how safely and securely we can participate in the opportunities without, taking on too much risk. Thank you.
Any other comments or questions from the panel? Got it. Go ahead.
Thank you, Mr. Chairman, and TennCare, thank you all for being here. And I thought I was good to go after I was speaking with you all earlier this week, but the response you just gave now has got me really thinking another question. So if this process never ends, then I don't understand, then why didn't we bid it when the contract was originally up? That doesn't make any sense to me. So explain that a little bit more.
So when I think I understand your question. When we bid the contract, we included the systems build, but we also include as a component of that contract, essentially special projects and modifications. That was in the original RFP. And sorry if I was not clear about that earlier. There is a bucket it's essentially called special projects and modifications. It's essentially the things that we know we're going to be told to do or instructed to do legally in the future, but we don't know about them right now. Now that bucket has had to grow over time, over 11 years, because originally it was scheduled to be a 7-year contract. And because of the PHE, we're entering year 11. So we have had to grow that bucket. But there was a component of the original RFP that was specifically addressing, we know there's going to be these other modifications that have to come. And so that was part of the bid of all the bidders that bid on that at that time.
Okay, so at what point will you all say, okay, now let's rebid it? Because there's always going to be special projects coming up. So at what point will we stop getting amendments and say, okay, now we're going to reissue a new RFP?
Yeah, that's a good question. So the new RFP will go live about Thanksgiving. It would have been several years ago, but because of the PHE, we intentionally delayed it because we feel like potentially bringing in a new vendor when we were trying to unwind, our population from 1.8 to 1.4 would have been a strategic mistake. You bring in that introduces a lot of uncertainty that could have disrupted the process. So we delayed that, but the new competitive RFP will be released later this year.
Okay, thank you, Mr. Chairman.
Thank you, Chairman Hicks. Any other comments or questions? Do we have a motion? Motion by Senator Yeager. Have a second by Chairman Bailey. All in favor say aye. Aye. Opposed nays. Ayes have it. Thank you. Go on to contract number 6.
Our next contract we have before you is a competitively procured contract with the Keystone Peer Review Organization, or KeyPro. In this amendment, we're requesting to exercise the first of 2 renewal option years, and we do not need an increase in max liability. In this contract, KeyPro manages our medical appeals process and the call center that's associated with that.
Have any discussions or comments from the panel? I see none. We ready to vote? All in favor say aye. Aye. Opposed nays. Ayes have it. Thank you. Go on to contract number 7.
Our next contract we have before you is a competitively bid contract with Maximus Health Services. We're requesting to extend the current contract by 12 months and increase the maximum liability for that. The main function of this contract is Maximus operates our provider data management system, or our PDMS. This is essentially the system that handles the enrollment and registration of healthcare providers.
We have a motion. Have a second. Any discussion from the panel or questions? I see none. Ready to vote. All in favor say aye. Aye. Opposed nays. Ayes have it. Thank you very much. Contract number 8 is up. And before we get started, Disability and Aging, you're on deck, so come on up and take your seat. And in the meantime, Mr. Mayo, for the benefit of Senator Watson, would you enlighten the panel and him on where you went to high school?
Yes, sir. I'd be more than happy to do that. Of course, I am Eric Mayo, Senior Policy Advisor for HR. I went to Marion County High School in the very large town of Guin, Alabama. You'll have to forgive me for that, being south of the border there.
Thank you. Go ahead. You're now recognized.
Yes, sir. Thank you so much. With me today, I have Sherry Graves, our contract manager from DOHR, as well as Steve Brown, Talent Management Program Director. We're here to request the approval of an amendment for our sole source contract with Lipscomb University for the Accelerated Leadership Institute. We call that ALLI for short going forward. Our request is to adjust the contract end date to 2029 from the current 2026 and increase the max liability to $706,414.
Do I hear a motion? Have a motion? I hear a second. Anybody? Okay, good. Thank you, Representative Littleton. Any questions for Chairman Watson?
I'd like to talk about just for a minute. So, Mr. Chairman, they're proposing to go ahead and absorb if I understand correctly, the 3 one-year extensions, requesting a 5-year contract through 2029, which is a little bit against the grain of what this committee has normally done. We usually do 3 years and then allow 2 one-year extensions. So I bring that to committee's attention. And then this has existed since 2015, correct?
Sorry, yes, sir. That's correct.
So we're in about year 10.
Yes, sir.
So you've had their 2-year cohorts. So you've had what, 10 times, let's say 25, just for easy math. So you've had 250 people go through the program. Is that right?
192
Okay.
individuals. Yes, sir.
So out of 192 of those, how many of those are still employed in state government?
That's an excellent question. I might let Steve, do you know off the top of your head that answer, Steve?
Use your mic, please, and pull it down in front of you.
Currently, this program is designed for the fellows, as you know, the governor's fellows. And I can tell you that 65% of the fellows that have graduated the program have become state employees, 65%. And that's was the background of why this program was designed.
Right. That was Mr. Chairman, that was the reason for the question is if you look to the members, if you look at the program design, it's to develop public leadership skills in state government. And so the expectation would be that the retention rate of those who go through the program would remain in state government. And I suppose 65 or 70% if I compare that to graduate medical education, that's probably about the same as residency programs. About 70% stay where they trained. So that's probably an acceptable percentage. I thought the committee should know how effective this is in actually preparing individuals for state government within and then remaining in state government, not having taxpayers pay for something and then people taking that skill set and going off into another industry and using that skill set that the taxpayers paid for. I would, again, just bring to the committee's attention, this is a 5-year extension versus the normal 3 and 2. Yield.
Chairman Egger.
Thank you, Mr. Chairman. Chairman Watson's observations are well taken with me. I think we have a long-standing tradition or policy that we do not approve 5-year contracts. I believe it's a 3-year contract with annual extensions. And this is not, what they're proposing is not in accordance with our policy. I just don't think that we should change this unless the chairman or the director want to have a reason to think that we should, but I'm not willing to make this change. I think that 5 years is just too long. Thank you, Mr. Chairman.
Two things to answer your question is we could probably do a 1-year extension, see how they how y'all react to that, if that'd be okay. You think that'd be fine? So would you like to make a motion that we entertain a 1-year extension?
So moved.
And a second by Senator Watson. Let's accept let's vote on the exception, the amendment. Let's see. $200,000 on the dollar amount instead of 500 something.
Unless there was an objection, my motion would include that.
Okay, and Senator Watson's okay with that, so let's vote on that amendment. Any questions or comments? Senator Watson?
I want to make sure that all the committee members understand what I think there's a little bit of, I would yield to the executive director maybe if you would, Mr. Chairman, and let him explain exactly why we're doing it this way.
Okay, recognized.
Thank you, Chairman. Boyan Savage, Executive Director of Fiscal Review Committee. So the amendment and the contract that's before us is with the initial term of August 1 of 2024 through July 31 of 2026. So it's a 2-year contract. The committee's general policy is to accept 3-year contracts with 2 1-year extensions. The amendment before us today is to extend the contract by 3 years at this time. So the proposal here and the motion that was made is to only allow a 1-year extension, which would put the contract at the 3-year mark and revise the additional funding that's provided for that extension. The current ask is $538,000 in additional funding. This motion would provide $200,000 to fund that additional year.
Thank you. And this probably is a question just for the executive director. I just want to make sure, and this is consistent with both, like this contract can be extended in this one year way. Like I'm just trying to make sure the contract doesn't have any provisions that stop us from doing that would stop this. And I guess the other question is I mean, I guess we're asking them to bring that back, and if they bring that back, we'll approve that, or we're trying to change it ourselves? I'm trying to make sure that I understand what this committee's role in evaluating a contract is and what it's trying to do.
Sure. Thank you, Senator Yarbrough. Good question. So 2 parts to that. The first part is the timing of it. Would we negatively impacting the contract as a result of the shorter time? We've looked at the schedule of the cohorts, and each cohort has orientation, certain summits that are scheduled, group presentations, and finally graduation. 1-year extension would not conflict with that schedule. So we would be approving that 1-year extension with the additional $200,000. At this time, the department would not have to come back before us for that specific approval. Presumably, the department would be back before us the following year, seeking the same for another year.
Follow
up? Then just the role of the committee in terms of like whether are we recommending this to the department? What are we doing in terms of approving this or changing it ourselves?
Sure. So the rule of the committee has been that we prefer 3-year contracts with 2 1-year extensions. So we've had instances in the past when contracts were presented to us that did not meet that expectation, and we have made changes at the committee meeting to revise the approval of the amendment and the terms that were approved by the committee.
Follow up? Any other comments or questions? Just a minute. Oh, Representative Shaw.
Thank you. Mr. Director, explain to me then what would have happened if they'd have brought a 3-year contract?
Representative Shaw, so with this approval, we are essentially having a 3-year contract in place. And then the department will have options to extend in the future by 1-year increments. The initial contract was placed as a 2-year contract. So this gets us to that 3-year mark.
Any other comments or questions from the panel? We need to vote on the amendment that Senator Yeager brought and Senator Watson seconded. All in favor of that amendment, say aye. Opposed, nays. Ayes have it. Now we go to the regular contract as amended. Any other comments or questions on the contract as amended? I see none. We're ready to vote. All in favor, say aye. Aye. Opposed, nays. Ayes have it. Thank you, Mr. Mayo, to that question. Okay, let's go to disability and aging.
Thank you, Mr. Chairman. My name is Trey Jones, and I'm the Legislative Director for the Department of Disability and Aging. Joining me today is Deputy Commissioner Andy Kidd for Fiscal and Administrative Services and our Legislative Assistant Director, Dane Mortensen. Today, the Department of Disability and Aging is requesting approval for an amendment to our current contract with Harmony Health Foundation. This request extends the contract by 1 year and adds $110,000 to the maximum liability. This partnership has created a foundation for improving dental services for people with intellectual and developmental disabilities in Tennessee.
Any comments or questions from the panel? I see none. We're ready to vote. All in favor, say aye. Aye. Opposed, nays. Ayes have it. Thank you very much.
Thank you.
Now we'll go to public chapter review presentation, and we do have something on other business. So while he's presenting that, I'll pass that out to you. It was an issue that Senator Yeager brought up at the very beginning. So you're recognized for the public chapter review.
Thank you, Chairman Gardenhire, members of the committee. Once again, my name is Boyan Savage, Executive Director of Fiscal Review Committee. As you're well aware, we are statutorily required to annually present to you a comparison of actual and estimated fiscal impacts on recently enacted legislation. The requirement is to present at least 5 of such public chapters. And for this cycle, we've selected a total of 8, with the 8th one being a combination of multiple similar bills. So I'll get right to that. The first one on the list is Public Chapter 590 of 2020. It's a relatively simple, straightforward one. It removed certain per diem rate restrictions in place for utility district boards of commissioners within Blount County. And we have estimated an increase in local expenditures of up to $16,200 on a recurring basis. And this was a permissive increase in expenditures. So we think this one touches on the subject of legislation that authorizes certain action. We're often asked in fiscal notes why we have estimates on legislation that only authorizes rather than requires certain actions. And our assumption is always that an authorization will be implemented. And so we always reflect the cost of that implementation. So the assumptions behind this analysis were, once again, relatively straightforward. There are 3 utility districts in the county. Each district contains 3 members for a total of 9 members. This legislation would allow them to receive a maximum per diem rate of $300 per meeting, as opposed to $150, and they have a maximum of 12 meetings per year. So we've essentially assumed that each member would be in attendance for every meeting on a monthly basis. And we've compared that to kind of the maximum cost under law that existed at the time. So that's the difference is $16,200. What we've seen is relatively close. In the first couple of years, we have not gotten to that number exactly. But what's interesting here is that in the most recent 3 years, we are actually over that maximum amount that we've indicated. And so this table outlines each district's per diem payments over time. And I'll highlight a couple of points here. First, the numbers in orange in the table. You'll notice that the first 2 districts have immediately changed their rates. So they've adopted the higher rates to $10,200, those 2 numbers there. The 3rd district, the Fire Protection District, was a couple of years behind in adopting the higher rates. The second point here is that the numbers in red, you'll notice that 2 districts have 5,400 and the first one is at 3,600. What we have found is that one of the commissioners on that first district was not accepting per diem at the time. And so that's the result of the difference in calculations. After the rate has been increased, that commissioner has started accepting the rates too. So we're comparing to somewhat of a lower base than what we initially assumed. The second public chapter is 547 of 2021. This one has 2 parts to it. The first one required the Department of Children's Services, Higher Education Commission, TBR, and the state's public institutions of higher education to establish a foster care youth outreach liaison pilot program. And that requirement was to be placed at a minimum of 5 institutions. And it was a 3-year pilot program that was to terminate on June 30th of 2024. The second part to this legislation was that it expanded the Tennessee Hope Foster Child Tuition Grant to eligible 17-year-olds who have been placed in state custody, permanent guardianship by the DCS, or placed for adoption by the DCS or their adoption contract agencies. And so the estimate on this was an increase in state expenditures to the Lottery for Education account that increased every year. The first year was approximately $28,000. Second year, more than $44,000, and year 3, more than $61,000. The assumptions behind that estimate, once again, in 2 parts. The first one dealing with the liaison pilot program. we have assumed that any increase in expenditures to the department, higher education institutions, other state agencies would be not significant. They would utilize existing staff and resources to implement this pilot program. The second part deals with the HOPE tuition grants. We've had a lot of back and forth with Higher Education Commission and department when this legislation was proposed. This was an administration bill. And the challenge there was determining not only what the population of impacted students may be, but how many of them would meet all the other criteria that is in place for qualifying for this grant. So it was a relatively easier task for those already enrolled in institutions, but for those that are not enrolled that may be encouraged to enroll, there were some unknowns. So after those discussions, we have determined that an average of 5 students per year would qualify and receive this grant. The grant amount is $5,549. We've assumed a 57% retention rate. So essentially, from the first 5 students in year 1, 3 of them would retain the grant in year 2, and 5 new students would be added. So we're going from 5 to 8 to 11. What we have seen is quite a bit of a higher cost than what we've assumed. As you can see in, for example, year 3, 23, 24, we've had exceed 61,000. The actual impact has been 244,600. For the first part of this, the pilot program, we've had the minimum requirement for 5 institutions. 18 institutions participate in the program. There were no costs for participation. Existing staff and resources were utilized as assumed on the fiscal note. The program terminated on June 30th of 2024. However, the operations continued. And as if you may recall, earlier this year, Public Chapter 333 reinstated the program as a permanent program, and it opened it up to private institutions as well. For the second part of this, as you can see in this table, once again, in year 1, we have assumed 5 participants. What we've seen is 20 of them. So a magnitude of 4 higher than what we've assumed. And that has kind of continued. That growth year over year is what we're seeing, but at a higher level than what we have anticipated. The third public chapter on the list is 699 of 2022. This one created a common carrier license to be issued by the Tennessee Alcoholic Beverage Commission for individuals and entities that transport wine from a winery direct shipper or fulfillment house to in-state consumers. It required applicants to submit a $300 application fee and an annual $1,000 fee for each license. And then it made a couple of other changes. It expanded the Class C felony charge, punishable by fine only, for shipping wine without an authorized license to include all alcoholic beverages and beer. And then it also established a Class B misdemeanor offense, once again punishable by fine only, for delivering alcoholic beverages or beer to an individual without checking for proof face-to-face that the individual is 21 years of age or older. What we've estimated here is an increase in state revenue to the ABC in year 1, 5,200, subsequent years, 4,000. And we based that estimate on Virginia. Virginia required a similar license, and they had 5 licenses in place. We've assumed we would have 4, and they would be licensed by January 1 of 2023. And then we made the same assumption that we make on all felony misdemeanor related legislation when it comes to fine revenue. We assume a not significant increase in fine collections. What we've seen is close to that estimate. As you can see, year 1 was slightly lower. And that trend continued over the years, and we'll get to more detail on that. So there have been essentially 3 licenses that were issued versus 4 that we assumed. However, in the first year of implementation, we did have 4 applicants. As we assumed, the applicant did pay the $300 application fee that was retained by the commission. However, they withdrew their application and never paid that $1,000 licensing fee. For the second year, we remained with 3. And this previous year, 24-25, one of the 3 was with the same company, just a different legal entity. And I believe they are not renewing their license. So we have 2 licensures issued in this previous year. There have been 0 Class C felony convictions, but we did have 1 Class B misdemeanor conviction, and that fine was collected. ABC collected $1,500 in fine revenue, and that was deposited to the general fund this previous year. The next public chapter, I'm sure you're all very familiar with. It is 1071 of 2022. This one received unanimous approval by both chambers. It enacted the Mental Health Treatment Act of 2022 to create programs to facilitate the implementation of new and the continuation of existing mental health court treatment programs within each county. The fiscal note on this is rather significant. We've estimated an increase in state expenditures of $5.7 million in year 1 and $5.5 million in subsequent years. We have also estimated an increase in local expenditures of at least $450,000 on a recurring basis. Some of the assumptions behind those estimates were that counties, for the most part, can utilize their existing judges, existing clerks to preside over these cases, and they will utilize their existing space within their courthouses. So no significant impacts from those requirements. The calculations behind the numbers were kind of based on the sample of the total of 82 recovery courts that were there at the time due to some overlap of services. So essentially, we have looked at grant funding to 57 recovery courts that were in place. That table kind of breaks down those numbers a bit. So the average grant per court was $116,570. And so we assumed that that would be the average grant amount going forward for these mental health treatment courts. We have also assumed that we would have 45 courts that would receive this amount. The Department of Mental Health and Substance Abuse Services would require 2 additional positions. There were various other costs that were included there on a smaller scale. I'll highlight the system updates of $250,000 one time, and then a recurring $10,000 cost for hosting, maintenance, support. On the local level, to be fully transparent, we've struggled with that aspect for the most part. We didn't think there would be an extremely significant cost on the locals, but we did recognize the potential for some smaller costs. So we assumed that each court would, on average, incur at least $10,000 in local expenditures, and that amounted to $450,000 total for the 45 courts. And then finally, we assumed that no federal funding would be provided for this. What we've seen so far is kind of a build-up to the estimate that we have provided. As you can see, in the most recent fiscal year, we have just under $4 million in actual costs. And I'll go through those details here. The department did receive and hire 2 additional positions in December of 2022. Those costs are relatively in range of estimates. We've had some overall increases over time, so they will not match up exactly. But year 1 was somewhat lower because the positions were not hired at the very start of the fiscal year. As of today, 16 additional mental health treatment courts have been implemented for a total of 19 courts. And there are currently 37 counties in the state with access to a mental health treatment court. The table breaks down by each year the number of courts, the total grants received, and the average grant. And you can see that the average grant was $185,000 in the most recent fiscal year for a total of $3.5 million in grant funding. There were other costs here. Once again, I'll just highlight the 140,000 for the one-time IT changes. On the local aspect, though, this review has not yet revealed a significant increase in local expenditures. Our staff has surveyed all mental health courts. We have received some responses, and so far, all of the responses that we have received have not indicated any significant increase in local expenditures. The assumption of no federal funding also turned out to be accurate. No courts reported federal funding associated with this. In your packets, I believe on the back of them, you have a list of all existing 97 recovery courts with contact information and details. I do want to point out that the department has indicated that 3 additional mental health courts are anticipated to be created in this fiscal year, with grant funding to increase to approximately $4 million. So we're approaching that initially estimated amount and kind of working our way to add these courts over time. Number 5 here is Public Chapter 214 of 2023. And this one is interesting, and it relates to some of the discussions that took place today on one of the contracts when it comes to implementation of rules and the timelines required. And I'll get into that now. So the public chapter simply created a new licensure under the Board of Cosmetology and Barber Examiners as an eyelash specialist. These are always a little bit tricky to score on a year-to-year basis because you typically have a biannual renewal cycle, new applicants each year. So the numbers kind of vary year to year, but we've essentially shown an increase to the board of $16,000 in their licensing fee revenue in year 1, $8,000 in year 2, and then $14,000 in year 3 and subsequent years. We've also reflected what you often see on fiscal notes, and that is the cost for our state strategic technology solutions staff to perform IT work on behalf of agencies. So we do reflect that cost in fiscal notes because those agencies do transfer those funds to the SDS. So the fiscal note reflected a one-time increase in cost of $7,000 to the board and a one-time increase in revenue of the same amount to SDS. Just very quickly, our assumptions on this were we assumed 200 new licenses for eyelash specialists in year 1, 100 in subsequent years. With the renewal cycle with year 3, we would approximately have 200 licenses in place, either initial or being renewed. For the service shops, we've assumed 20 new licenses in year 1, 10 in year 2, with renewals and new licenses. By year 3, we've assumed approximately 18 would be in place. And finally, I mentioned the SDS cost and revenue provision. Now, what we've seen is interesting. What the actual fiscal impact reflects here, as you'll note, is simply the cost to the board and revenue to SDS. So the work has been done by SDS and they have received their cost by the board. But you'll notice that in the increased state revenue portion, there is no revenue for the board yet, even though this public chapter was enacted in 2023. And so I'll kind of walk through the rule situation that we've had and that impacted these revenue collections. So rules and licensing fees were promulgated and adopted by the board on February 5th of 2024, examined by the Attorney General on April 8th of 2024, and filed with the Secretary of State on April 12th of 2024. Pursuant to TCA 45207, no rule, unless filed as an emergency rule, shall become effective until 90 days after the filing of such rule with the Secretary of State. So with the filing date of April 12, this new rule and fees were effective on July 1 of 2024. However, another provision of the law states that with certain exceptions, any new fee or fee increase promulgated by the state agency shall take effect on July 1 following expiration of 90 days after filing with the Secretary of State. And so since the permanent rules regarding the fees were not effective before July 1 of 2024, once again, they were effective July 11 of 2024, these fees could not go into effect until July 1 of 2025. And so during this time period, a small amount of licensing fees was initially collected, but those fees have been refunded. This slide kind of outlines just the population that we're looking at. Looking at that last column first, because our estimate was relatively close there. We've had 10 in year 1, 25 in year 2. Once again, we were in the 20 range. When it comes to eyelash specialists, we have not quite gotten to the point of that the fiscal note assumed of 200 in year 1. So far, we've seen 38 in year 1 and 44 in year 2. And once again, STS completed the work, and we've reflected those costs and revenues. The board did not realize any additional increases above those. Public chapter number 6 on the list is 392 of 2023. I'll kind of skip through most of this summary, but it essentially required TBI to develop a request for certification form to be completed by the court and submitted to the TBI prior to entering an order of expunction. And then it also authorized the clerk of the court to charge the petitioner an appropriate fee, which is $100, for those petitions for an expunction of the person's arrest record if the court with jurisdiction over the offense for which the person was arrested has no history of the arrest within the court's records. The fiscal estimate here was an increase in state expenditures of $285,000 in year 1 and $171,000 in year 2 for the TBI. And then an increase in local revenue associated with that additional fee to the tune of $27,500. At the time of this legislation moving through the process, TBI informed the legislature that the Bureau would be able to absorb the essentially estimated IT costs. Those amounted to $125,000 one time, $25,000 on a recurring basis. Little more detail behind the cost is that TBI would require 2 additional criminal history examiner positions. There would be that one-time increase in state expenditures of $125,000 for the system, and then recurring expenditures of $25,000 for maintenance. And once again, the local revenue of an estimated $27,000. What we have seen is a relatively close numbers to the increased state expenditures portion, but we have not seen any evidence that the local fees have been charged. And so this slide, I'll skip through it, but it essentially just provides a little more detail on the cost for the positions. The TBI did get the 2 positions. The cost for the system upgrade was $146,000 versus $125,000 that we assumed. TBI informs us that they were able to absorb that cost. And then the maintenance cost is approximately $25,000, which matches the assumption on the fiscal note. Public chapter number 7 on the list is one that we're all familiar with. It is the franchise tax refund, 950 of 2024. A lot of this information is, of course, public knowledge, but it received a lot of questions as this legislation of the estimate and potential impact. So we wanted to highlight how that compared to what the fiscal note reflected, and then also highlight one of the issues with quantifying the actual impact with the other portion of this legislation. But effectively, this legislation required the department to issue refunds to taxpayers in certain instances for franchise tax. And then it also changed the formula for franchise tax on an ongoing basis. What the estimate when the fiscal note reflected was that 1,552,000,000 would be immediately transferred from the general fund into the new franchise tax refund fund, and up to that amount would be refunded to taxpayers. Additionally, we have essentially estimated a $400 million decrease in actual franchise tax collections on a recurring basis starting with year one. Somewhat lower in year one, 405 million starting with year two. One final estimate on this was that there would not be a significant increase in expenditures for the department nor the Attorney General in implementing the process and issuing these refunds. What we have seen here is, of course, the same amount was transferred. The estimate reflected on the fiscal note was transferred into the new fund. So the $1,552,000,000 went from the general fund into the franchise tax refund fund. The actual increase in of that amount, I'll go to this next slide to kind of break that down a little bit. 0 refunds were processed in that existing fiscal year, so 23-24. All of the refunds have been processed in 24-25. Of that 1.55 billion amount that was transferred, 1,437,000,000 was refunded to taxpayers. The difference, 114 million, was then reverted to the general fund on July 1 of this year. The number of taxpayers that received the refund is broken down in that table, and it totals to 58,487. The fiscal estimate contemplated that there is a potential pool of approximately 98,000 taxpayers that could seek the refund. However, there's a lot of uncertainty with that due to small amounts of refunds. Many of them would not go through the process. Many of those taxpayers may not be existing today to even seek those refunds. No increase in state expenditures attributable to the development of the automation process and no impact to the Attorney General have been realized. One thing that we wanted to highlight here is that estimate on the decrease in actual collections going forward. And this is a challenge that we have for many of the public chapter reviews that involve tax legislation. Tax collections, they're difficult to forecast on an ongoing basis without any legislative changes. They're impacted by many different factors. So we don't have often the best sense, unless certain information is tracked in various instances, we don't have the best sense of what the actual impact has been. At this point in time, working with Department of Revenue and kind of analyzing the collections, we still think that that estimate of year one, 393 million decrease is the best estimate that we have of the impact. And just kind of to provide the sense of where we are for year-to-date collections, with the preliminary collections for the full year, fiscal year 24-25, the F&E tax collections are approximately 1.4% or 53 million lower than the official budgeted number for F&E tax collections. So we are coming in very close to what was expected in the budget for that fiscal year. And finally, the last public chapter set is for highway vehicles. We see these legislation year after year. They essentially authorize all-terrain and off-highway vehicles to operate in specific segments of roads. We have 6 here that we have taken a look at. And our assumption on these that the fiscal impact is not significant. So on each one of these, we've said no significant cost, no significant revenue. The basis on the assumption is pretty straightforward. There will not be a sufficient number of violations for unauthorized use of all-terrain vehicles for the government to experience any impact on revenue or expenditures. What we have seen from all of these public chapters is not significant impact on all of them, except for the very first one. We've had an increase in state expenditures of 1,500 to the highway fund. And it's that first bullet point on this slide. So with that first one, the Department of Transportation installed 6 signs along the designated portion of that road, with each sign costing $250. This resulted in that one-time cost of $1,500 that was not contemplated in the fiscal assessment. For all of the other ones, there have not been significant costs. I'll kind of skip through the next 2 slides. But this final slide addresses that situation. So according to the department, that first public chapter that was enacted in 2020 was the first of its kind to be enacted, which is why signage was installed at the time. Since then, while general guidance for such signage has been developed, there's no formal policy requiring signage for every subsequent public chapter. And instead, responsibility for determining whether to install signs has been delegated to regional offices based on their assessment of local needs and relevance. There's no statutory requirement at the state or local level for installation of these signs. What we've seen from all of the other 5s is that no signs were directly installed as a result of this, these public chapters. And once again, not once again, but we have reached out to the Department of Safety to look at vehicle incidents and crash reports to see if we had seen a significant change since these authorizations were implemented in those localities. And they provided us data that confirms that we have not had a significant impact to the number of accidents due to the implementation of any of these public chapters. And that concludes our report for this year, and I'll be happy to.
Any questions or comments from the panel? Representative Baker.
Mr. Chairman, I know you talked about the hairdressers, but the point there was here we had a calendar year, something I guess embedded in statutes. It says the 90-day Secretary of State rule, if it rolls over past July 1, can't be effective till the following fiscal year. Is it something that we as legislators could change that rule that says a rule could go into effect the first month after the 90-day period? So we wouldn't wait almost 11 months to get a rule in effect? And is that something that would require legislation? And maybe any of my colleagues can answer that.
Anybody want to weigh in on that?
Well,
Senator Watson, Chairman Watson.
I think historically, the Government Operations Committee and the legislature has been careful about fee increases. And what happens is entities are doing a certain service and they're not paying any kind of licensing fees. And then they come to the legislature and ask us to create a licensure for them. The minute we do that, under the statute, any licensing board has to be self-sufficient because they are not actually entities of state government. They are quasi-state government. The government has oversight of them, but the board are creations of the profession that creates the board. And so the legislature has long had a position of if you create this new licensing board and give authority to that board to charge for that service that heretofore there has been no charge for to the individuals, then people should have ample time to adjust to the fee. Now, under some circumstances, the fee, like in this one, might be $25. In other circumstances, it might be $400. And so I think the general practice of the legislature over time, and the reason that July 1 exists, is to allow for one, rule development, but two, to allow individuals to adjust to the potential fee increase that would occur to fund the board that services them.
Go ahead.
I kind of follow that, but I mean.
Put your mic on. Put your mic on, please.
Got the 90-day Secretary of State period, and then by pushing out to the first effective month past that, I mean, that's almost could be up to 4 full months. And obviously, even before that, all the awareness of the rules should have been publicized and out there. It just seems like we put an arbitrary calendar date in there that we should be more flexible in looking at another kind of implementation date process than that. It just hits me as that way.
Well, I think it's actually not an arbitrary date. It's actually the fiscal starts the new
Understand
fiscal
that.
year. So the reason that date was chosen is because it helps for the planning of the cost of the board if they know on a date certain what their budget is. If you have multiple or then arbitrary dates throughout the year, then it becomes more difficult to budget and fund the board. And when they come back, because remember, under the government operation rules, there is a sunrise provision. So when boards are created, there's a period of time where those boards are getting organized and developing, and they have to come back to government operations for their sunrise review. You would have at that point the potential that a board doesn't have the financial capacity to meet its financial obligations, and there it would be subject to government operations review because they don't have the resources to be self-sustaining, which the law requires them to be self-sustaining. So that 1 year period of time after July 1 allows for the collection of those fees, allows for proper budgeting so that the board can determine its operational expenses as well as what its operational revenues are in order to meet the self-funding requirement that the law has.
Great, thank you for that. Any other questions or comments from the panel? I see none. Is that it? Okay, great. Now we'll go to other business. And two things. One, Wednesday, September 24th at 10 o'clock in this room will be our next meeting. Please put that on your calendar. And second item of other business is I passed out a sheet of paper on a proposed concept that has to do, and Senator Yeager mentioned that early on in the meeting, that no company shall be eligible for a new contract or contract extension in the same service if that company has been penalized by a state agency for significant violations in that service within the past 5 years. I have a company in my district that's owned by a female that lost out to a company that had these types of fines levied on them, 309 unlicensed security guards in Tennessee, and paid thousands of dollars in penalties. And yet a contract didn't slip through this committee, but it did slip through to get them done. It wasn't done by the current and new Commissioner of General Services, but evidently the past one let this slip through on this company. And I've asked our executive director to pull that contract for us to review it and see just what went down on the awarding of that contract. So I would love to have at least a motion to in a second to for this kind of concept that we look at contracts in the future and review the ones that we might want to look at to make sure that we're not awarding contracts to somebody that's been a bad player. We have a motion by Senator Yeager. Second. Any comments or questions on this? Yes, Representative Big.
Is the wording significant violations or just any violations?
Significant. And as someone once said one time, a long time ago, kind of like pornography, you know it when you see it. You know, and I'm not talking about somebody that just a typo on something and there was a violation, but a significant one. So any other comments or questions? We have a motion and we a second. Any other comments and questions? If not, I would like to have a vote. All in favor say aye. Aye. Opposed, nays. Ayes have it. Thank you very much. That concludes the business for the day.
You got a cold, don't you? You have a
Good to see you.